Hi, I'm Reed Bloodworth, a business litigation, estate and trust litigation attorney in Orlando, Florida. Today, I wanted to discuss some common scenarios in trust and estate litigation where it may be in your best interest to contact a trust and estate litigation attorney. These scenarios consist of situations where a will or trust has been changed, and the person who was changing the will or trust suffered from potentially some type of health issue or had been isolated from their family. Some of these common scenarios are the person making the trust or the will had dementia or Alzheimer's. Another common one is the person was in very poor health, was heavily medicated, potentially on their deathbed. Another common scenario is when the person changing the will or the trust has been completely isolated from the rest of their family by someone else. These types of situations are situations where wills or trusts are changed under very suspicious circumstances. For example, if someone has dementia or they have Alzheimer's or they are heavily medicated due to a severe medical condition, or perhaps they're in hospice just because they're very elderly. These are all situations where the person making the change to the will or trust may not have had the mental capacity to make those changes. The situation where the person changing the will or trust is isolated from their family. This is sadly a common scenario where an elderly person is not allowed to speak with potentially their sons or daughters or other family members, and they are kept isolated from those people who were beneficiaries under a prior will or trust and are surprised at the time of death or sometime after the person dies to find out that they are no longer beneficiaries, that the person who had isolated them is now the sole recipient of all of that person's estate. These types of situations give rise to various claims. Some common ones are undue influence. Undue influence is a situation where the person who had the will changed for their benefit had a control over the person that was making the change. They may have had a high degree of difference in their mental abilities, which harkens back to the various medical conditions we talked about. Or they simply could have isolated this person. They could have berated them, harassed them, done a number of things to make them change their will or trust to name the new beneficiary the sole beneficiary of the will or trust. The other very common cause of action in this situation is lack of capacity. When someone has Alzheimer's, they have severe dementia, they are heavily medicated because they're dying of cancer, or they're very elderly and they're in hospice care, these people typically do not have the mental capacity to understand what it is they're doing when they change a will or they change a trust. The law requires a person to have the mental capacity to understand what it is they're doing at the time they execute a will or trust. If they don't, that will or trust can be challenged in court and can be voided so that the proper beneficiaries receive what they should have to begin with. These are just some common scenarios, and they're scenarios that if you experience this, it would likely be in your interest to contact a trust and estate litigation attorney. So again, my name is Reed Bloodworth. I'm an attorney in Orlando, Florida. Give me a call. Let's talk about what happened to you.